Hello and welcome to Rightly Decided, the mostly originalist takes of the litigators of Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorneys Nathan Seltzer and Clayton Calvin, and our Director of Litigation, Chance Weldon. We are bringing you Supreme Court cases this week. We are actually bringing you Supreme Court cases that dropped last week. We are covering today the Voting Rights Act case that dropped last week, as well as a standing case, because y'all know how much we love to talk about standing.
That's actually true. Yeah.
First Choice Women's Resources Center versus Davenport. Because we want to keep you all on the hook, because we know everybody's interested in the VRA case and wants to talk about that. Let's talk about standing first, because it's an interesting set of facts. So, Nathan, will you go ahead and give us a 10,000-foot view of the facts in, I suppose we're going to call it First Choice, because Davenport isn't really the appropriate name for it.
Yeah, the new Attorney General of New Jersey is now having to deal with this case and actually losing this case. So the First Choice Women's Resources Center is a case coming out of New Jersey. It deals with whether or not a nonprofit organization has standing in federal court to sue about being subpoenaed in state court. So that's a little confusing. So how do we get there? So in 2022, the New Jersey Attorney General, Matthew Platkin at the time, established a reproductive rights strike force. And that strike force was really concerned, as you can tell from the name of it, it was concerned with abortion and with pregnancy centers and things like anything related to abortion. So eventually the strike force issues a subpoena to a pregnancy center, the First Choice Women's Resource Center in New Jersey, and it has mandatory language to comply within 30 days, and it needs to disclose a number of things. Some of the things it needed to disclose, there was actually 28 categories of information it needed to disclose, and then those categories had subcategories. And some of those categories include up to 29 different subcategories. So you're talking about hundreds of categories of information, but most relevant here is a donor list that they needed to produce the names, phone numbers, addresses, places of employment of all individuals who had made donations to First Choice by any means other than through one specific webpage. The subpoena, for those of you following along, you think a subpoena is something that's legally mandatory to comply with, to provide information. Often they're issued by courts, but attorney general's offices can issue them also. And
in this particular state, in New Jersey, the attorney general can issue a subpoena.
Yeah, and did. So the attorney general issued the subpoena, and it says in the subpoena, failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided by law. And it actually said that twice in the subpoena. So why would I say that? Everyone knows that you have to comply with the subpoena, right? Why do I mention that it has mandatory language in the subpoena? And it's because as they're litigating this case, the lower court concludes that because the subpoena is not self-executing, that the attorney general would have to bring an action in New Jersey state court to enforce that subpoena and compel compliance with it. And so they said because he had not done that yet, that the First Choice Women's Resource Center had not been injured yet. They had no injury just because they received this subpoena.
So I think it's important to stop for a moment and say why that matters, right?
Yes, because standing.
Yeah, because of standing. In order to get into court, you have to show that you have an injury in fact that's caused by the defendant that you're suing, and they could be redressable by a court order. And so what they were arguing here, what the lower court held, and you could talk about that a little bit more, was, and what the government argued was, you're not really injured when we sent you this subpoena that demanded that you turn over documents or face penalties. That's not a real injury because we haven't taken you to court yet. It was a suggestion.
It's just a suggestion. The language, though, of this subpoena is pretty dang strong. Something along the lines of failure to comply with the subpoena will result in all of these terrible things.
Yeah. Well, it says may. It says failure to comply with the subpoena may render you liable for contempt of court and such other penalties as are provided by law. So may, I mean, so maybe you can just ignore it, right?
So just really generally, what we're dealing with here is a pro-life pregnancy center. The attorney general's office has issued them a subpoena and said, give us your donor lists. Yeah. And they've turned around and said, no, we don't have to do that. That's a violation of our First Amendment freedom of assembly.
Right? By the way, of course, attorneys general can investigate criminal wrongdoing and allegations, but in this case, no one has alleged that First Choice Pregnancy Center did anything, or First Choice Women's Center did anything wrong, including the attorney general. And even though the attorney general obtains a ruling in district court saying that he would have to bring a separate action in state court and that therefore there's no injury yet, the attorney general did bring an action in state court saying that that First Choice violated state law by not complying with the subpoena. So it's a bit of a hypocritical.
So what does the Supreme Court end up saying?
So we eventually get there that well, actually, why don't you go into that?
Oh, well, I think what ends up happening, because we've been talking about it for a while, so what ends up happening is the Supreme Court says, no, you do have standing, right? Whenever they demand that you turn over these documents, turn over your member list, that you do, in fact, have standing to challenge that, because at least since the 1950s, what the court has repeatedly held is when the government comes in and demands your private members list of these political organizations, whether it be women's health organizations, whether it be the NAACP in the 1950s, whether it be Americans for Prosperity in the Bonta case a few years back.
And we've had a case on this along these lines too, right?
We had litigation on this when we were representing the Young Conservatives of Texas. When the government demands a members list, through subpoenas or discovery or otherwise, that is a First Amendment injury, and you have standing to challenge it. Doesn't mean you'll always win, but it is in fact an injury. And so to argue that there wasn't an injury here for standing purposes, the Supreme Court rejects that outright.
And there's actually, so first of all, this is a unanimous decision. The court has absolutely no trouble with this. And there's a great line from Justice Gorsuch, who authored this opinion at the very end. It's the last paragraph. I'm just going to read the whole thing. Since the 1950s, this court has confronted one official demand after another, like the Attorney General's. Over and again, we have held those demands burden the exercise of First Amendment rights. Disputing none of these precedents, but seeking ways around them, the Attorney General has offered a variety of arguments. Some are old, some are new, but none succeeds. And that's the point ultimately that Justice Gorsuch is making, and that the entire court agrees with, is that just the demand is an injury. It is a burden on your First Amendment right. And that's it. That's all that you need to get into court. Even if it's non-self-executing, in spite of all of these arguments that are made. I would like to walk through a little bit these arguments that are raised, because I think that they help us examine the contours a little bit of standing in this context.
Can we talk about the preclusion trap a little bit?
Yeah, sure. Let's talk about it.
So the way that the court frames this up, and it's really important, the AG is making a disingenuous argument. And I kind of explained it was disingenuous because they actually were bringing the case in state court. But it's also, in the background, we have this issue that if the court took the AG's claim at face value, then and it said that you have to go to state court first to vindicate your right, and then only if the state violates your right, then you have a constitutional claim and you could bring in a 1983 suit. The problem that relies is it is a trap. So if you bring a case in state court and you lose, there's a principle that is time honored called res judicata that says if you lose a case, that you can't bring a different case challenging the same issue. So if you lost, that they said that this is not violating your constitutional rights in state court, then if they tried to bring this exact case in federal court, they would say that that's barred and you could never bring this claim.
You don't get two bites at the apple.
You don't,
right.
Of course, and we agree with that. In society, we don't want endlessly litigants bringing the same case over and over again. That makes sense. However, they're saying that the injury hasn't occurred until it gets into state court. So you can't bring it in federal court in advance because it's not ripe, meaning that the injury hasn't happened to you yet. It just maybe will happen in the future at some point. But then you can't bring it after state court because of res judicata, so you could never bring this claim in federal court. That's the preclusion trap, and as the court rightly acknowledges here, that's been dealt with in a case called Nick v. Township of Scott, and it's specifically 1983 is designed to allow you to litigate violations of your civil rights, and that's what they're allowing the First Choice Women's Center to do here. And importantly, they don't take any. We don't know if they're ultimately going to win their 1983
This is
suit.
just about standing.
Yeah, just can you even have a case in federal court? And the court says, yes, of course you can have a case in federal court.
Yeah. And that's the holding. But okay, so Just as another interesting little aside, I think it's fascinating that Justice Gorsuch chooses to address this entire opinion at Attorney General Platkin. The Attorney General was replaced, which is why this case is versus Davenport. But at the time, it was Attorney General Platkin. And instead of, as we would normally see, I think, in opinions like this, the court addressing it's the state that does these things, the state, New Jersey, New Jersey, New Jersey. In this case, he singles out Attorney General Platkin and says, he. This is what the Attorney General is saying over and over and over again. And I think it's a fascinating, like, almost as if this is a rebuke not to the state, but to this particular individual in this kind of behavior.
Yeah, I mean, it's hard to read too much into it, but I think two things might be happening here. One, in this case, it was the Attorney General that, in fact, sent the subpoena, right? So in this case...
And created this strike force, this reproductive rights strike force.
And argued this case, too. This case was argued under the name Platkin, I believe.
Yeah, well, did Platkin? I don't believe he actually went and argued the...
I don't think he was the one in oral argument. Yeah. I'm saying that he was the Attorney General at the time.
Right, and so it was, in fact, the Attorney General who initiated the things that gave rise to this case. And now sometimes you may just refer to them as the state when they do that, so that might be part of it. And part of it, too, might be the type of arguments that are being raised here. Like, these are the type of arguments that state attorney generals argue in all of these cases over and over and over again, no matter how many times the court seems to say over and over again that standing is a common sense inquiry, that you're supposed to be looking at whether or not there's a real, an ordinary person would have some sort of injury or think that the government's demanding something. That should be enough for standing. Yet we see time and time again government attorney generals, the Solicitor General of the United States from time to time, making these arguments to circumvent what should be a straightforward analysis. And so maybe it's a little bit of side eye, and maybe it's just because in this particular case, the Attorney General himself was intimately involved.
Right. This was very much his baby as far as this situation goes.
Yeah. And to your point, the Attorney General, while the argument seems like it's been foreclosed by Supreme Court precedent and should have been an easy one at the lower court level, the Attorney General of New Jersey won at the district court and then won again in the Third Circuit. So we have, and then it takes the Supreme Court going back and being like, hey, remember that we issued precedent about this exact thing before? That's almost like what the Supreme Court's doing here. And it's like, how many times do we need to do this before they get the idea? And
it's and because the lower courts keep getting these things wrong, it incentivizes government lawyers to make these sorts of arguments because they're just trying to get cases off their dockets. I mean, if you're a government lawyer, you don't want to have to reach the merits of cases. So you're just trying to get rid of as many as you can. And until the courts speak clearly and just strike these things down, I think with a little bit of aggression, you're not going to see them stop because, I mean, even outside of the First Amendment context, when you think back to a few years ago to the Sackett versus EPA case, because it's outside of the context of the First Amendment, and there it was the federal government. And the EPA had sent compliance orders to Mike and Chantel Sackett, who had moved some dirt on their property to build a house. And the EPA had said, we think you moved this dirt into the wrong place, and we think that that's a violation.
Into a watershed, right? We think you've moved this into a wetland or a watershed or something. You can't put dirt here.
You can't put dirt here, and we think that it's a violation of the Clean Water Act, and it's going to be $30,000 a day in penalties unless you move it back. And then when Mike and Chantel Sackett went to court saying, well, we don't think this is a wetland, the federal government's argument was the same thing you saw here, which was, well, we haven't prosecuted you for it yet, so there's no real injury. You have to wait and accumulate these $30,000 a day in penalties every day until we decide to bring an administrative proceeding against you. And again, this was over a decade ago, and the United States Supreme Court also said unanimously in that case, no, you don't have to wait. And so this is something that happens over and over again, and it's nice to, I think, see the court finally putting its foot down a little bit and saying, we've been saying for over 50 years now to stop.
And that is the very first argument that the Attorney General raises. He says, this subpoena is not self-executing. It imposes no obligation on its own. And Justice Gorsuch says, the value of a sword of Damocles is that it hangs, not that it drops, which is such a powerful analogy here. It's the First Amendment injury is not that he's actually getting your list. It's that he's demanding your list. Yeah. That in and of itself is the injury, and that's sufficient. So it's similar in some respects to the Sackett case, but it's also kind of different in the sense that we're not saying you have to wait to be prosecuted. He's saying the demand itself is what is injuring you. People are afraid of donating to your cause because they can't receive assurances that these details, these donor lists, are not going to be handed over. That sword is just hanging there.
Well, it's interesting because I think in the opinion in Sackett, they used the sword of Damocles analogy as well, right? Because it gets compliance without prosecution. If you send a demand letter, it's the threat of prosecution itself that creates the injury, that makes you change your behavior when otherwise you may not have to. And that is sufficient for standing. And so it's nice as someone who litigates in this field to see the court speak clearly about it.
I promise I have not been ignoring Clayton. We've been struggling with some technical stuff this whole time. Are you finally with us, Clayton?
I'm so sorry. I think I am, but I can tell you that you guys are brilliant. I agree with everything that was said.
Absolutely. We are wonderful and we are never wrong. That's not true. Please don't hold us to that standard. You are a bit of a student of ancient history. Do you know the story of the sword of Damocles? Can you kind of tell us what that's a reference to?
Oh my gosh. I'm honored that you think I would have that off the top of my head. I don't. I think Chance knows it.
I do. In
Chance,
fact,
will you tell us the story of the sword of Damocles?
And I may get this wrong. So I wasn't aware that I was going to be asked this question about history when we started this podcast.
It's because I've been told not to pre-podcast you guys because then we sound too stilted.
Okay.
So what's the story?
So the way that I remember it is if it was a king and he had a sword that was held up by a single thread or by a single hair that was in front of his throne. If you came to invoke the king's favor, if you came to ask the king something, you had to do it under this sword that could drop at any moment. And it was the threat of the sword that made you not ask requests, or it's the threat of the sword because you had to actually present your case before the king under this dangling sword held up by a single hair or a single thread. And I think that's the sword of Damocles. Though don't quote me on that. It's been a long time since I've looked into it.
But the idea is we don't. It's not that the sword is going to cut you in half. It's not that you're actually going to be injured by making this request for relief. It's that the request itself is inherently dangerous because you have to kneel under the sword that's going to or could potentially fall and kill you.
Which is why the court has said in so many cases that you don't have to bet the farm in order to bring suit to protect your individual rights.
Or I think it's Doe v. Bolton. You don't have to subject yourself to the risk of arrest in order to protect your rights.
You don't have to bet the contender farm.
That's a deep cut.
Thank you, Nathan.
No one who listens to the podcast that doesn't litigate in the Fifth Circuit gets that joke.
Oh my gosh. All right. Okay, so then the second argument.
Wait, if I can't make a dad joke on this day that we're recording, because may the 4th be with you.
Oh my gosh.
Yeah.
Okay.
Sorry, we can cut
that. Happy birthday to Justice Sullivan, I suppose. Today is his birthday. Anyway, even if a non-self-executing subpoena seeking donor information can objectively chill First Amendment freedoms, his subpoena, the Attorney General's subpoena to First Choice, did not. So the next argument that the Attorney General raised is that his specific subpoena did not raise First Amendment concerns because he was going to allow the First Choice to have a separate website through which donors could donate, and he wasn't going to ask. This was a pinky promise. I'm not going to ask for the donation information from this specific website. So there's still an avenue for them to exercise their First Amendment associational right, but every other avenue is what I'm asking for. Why does that fail, Chance? Why does that argument not have any strength to it?
I mean, the whole reason you have a First Amendment is that you don't have to trust the government, right? Like the whole reason we have a written constitution with limitations is this idea that I don't have to mother may I to the government when I exercise my rights. And if you've cut off every other avenue to exercise, the pinky promise that, well, I'll leave something available for you, that's still an injury because, again, we're not even asking here whether or not they prevail under the First Amendment. We're asking whether or not this is an injury in fact that gets them into court. And if you've cut off every other avenue of First Amendment, protected activity, or if you've limited their First Amendment activity in some way by saying you can only use this avenue, that's still an injury. You should still have the right to challenge that.
Right. Like if we were to convert this into another First Amendment context and say, if the Attorney General had said, it's totally okay for you to pray and worship on Sundays, but any other day of the week you can't pray and worship, that we would obviously have standing to challenge that. Absolutely. There's no one who's going to say that that's not an injury, in fact. This is a very similar situation.
Right. one church or something like that.
Right. You can only pray at one church. You can't pray at every other church.
Right.
This is we've limited your First Amendment participation in that particular respect.
Well, not to mention the fact that the donors who had already given to this organization before this website was created or anything like that, like they're out of luck. Like they're still going to have their information's going to be made public. Yeah. And this was really a shot not just at First Choice Pregnancy Center or First Choice Women's Center, but it's a shot at any organization or any person who's thinking about giving money to a organization that it maybe is ideologically or politically opposed to the party in power, that we might come after your donor information, and that's something the court's just not going to tolerate.
Well, and I think that's exactly why maybe not why, but that plays into this being a unanimous opinion. This is something that should scare every American. This is something, regardless of what side of the line you fall on, this should make you nervous. Because a state that can come in and demand this kind of information from you is a state that has all kinds of power over your speech rights that we in America simply don't believe that the state has. So the last argument that was raised by the Attorney General in this case is that the First Choice doesn't have standing because a state court will soon issue a protective order requiring him to keep confidential any documents that the court produces. This is, again, that same kind of trust me, bro attitude where he says a state court will. They haven't yet, and I promise I'll agree to it when this issue comes up in front of the state court. But when this issue comes up, I pinky promise we'll keep them confidential.
Yeah.
It's almost worse than that, though, because it's relying on the court to like stop them from doing the very thing they're trying to do and arguing that they're going to do.
Right. This is actually asking the court to do something or require them to do something that they could theoretically just promise to do by themselves.
Yeah. Not even their own promise.
But also in an era of Supreme Court leaks, we've had, 2 in the last 3 years, major Supreme Court leaks.
Yeah.
I don't know that any court can sufficiently say, let alone any attorney general's office, that your data is safe just on their servers.
Yeah, and it's also just a weird theory that you're not injured because you can't go to court.
You can't go to court
because you're not really injured, because you could go to court and get a protective
But so the issue with the protective order also is that they already have the information at that point. They've already gotten the donor list, and they want to use the donor list to contact donors to see if they've been misled, even though there's no allegation of wrongdoing. But that even if they never release that donor information and it does stay completely secure, those donors are still being contacted, and they're still aware that their information has been requested and given to the state of New Jersey. That's a lot of stuff that's happened. Don't worry, a protective order will keep it from going any further is small comfort.
Yeah.
And I know that we've been dunking on these arguments a whole lot, but it's important to remember that they won on this stuff in the lower court.
In the
government
Circuit,
got this case dismissed. That was also true in Sackett, right?
Yeah.
In Sackett, where they had $30,000 a day in penalties all the way up to the Supreme Court. The lower courts in that case had kicked them out of court as well. And so the incentive structure for government attorneys to make these sort of angels dancing on the head of a pin, creative ways to keep you out of court is the incentive structure that they have. And so until the court really starts to really stamp its feet a little bit and say, stop, we're going to continue to see it.
Yeah, absolutely. On that hopeful note, in fairness, this is a little bit of feet stamping here. We are seeing from the Supreme Court just a little irritation, just enough. I think that maybe we'll start to see in the circuit some reflection of that attitude. But I don't know.
For keeping score,
please do sum up for those keeping score at home.
So 9-0, the court unanimously overturns the district court and the Third Circuit, which had not allowed a lawsuit to proceed, and they're saying yes, in this case, a lawsuit can proceed. The plaintiffs do have standing to bring a claim that their civil rights are being violated under Section 1983 based on the facts that we've told you today.
Okay, perfect. So let's move on to Callais. This is Louisiana versus Callais, which is our Voting Rights Act of this year. It seems like we have one of these every couple of years, but some of that is because this particular case has been floating and twisting around for a long time. So I'm going to go ahead and give a as close to brief as I can overview of the facts here, because this is complicated, and my apologies to the listener. This is actually a very complicated set of facts. back in 2022, so if you recall, you had to fill out the census in 2020. So based on the census information in 2022, the state of Louisiana created a new map. And in that map, they had what is called majority minority district. So one majority black district, which is what they had before 2022, but the racial makeup had kind of changed a little bit in the state of Louisiana. So they create this one majority minority district, and then black voters sued the state of Louisiana and said, hey, we're entitled to two districts where we are the majority. That was brought to the district court. The district court enjoined the map, and what the district court told Louisiana was, you have to make a new map or I'll make one for you. And the state of Louisiana said, oh, we really, really, really don't want that, because if they took the map that the district court had proposed, it would have pulled several major members of the House out of their district. So the Speaker of the House Majority Leader, and a member of the Appropriations Committee would have been districted out of their districts.
Potentially, yeah, potentially. We don't know for sure what would happen.
Right. Yeah. But the one that the court proposed, that was going to be the solution. So to avoid that eventuality and ostensibly to comply with Section 2 of the Voting Rights Act, Louisiana issued a new map which created for two majority-minority districts. And in this case, they were sued again, this time by non-black voters, alleging that two majority-minority districts violated Section 2 of the VRA, the same section that the district court just said was violated by the first map. Louisiana was the defendant in this case. The black voters moved to intervene. And Louisiana then dropped out of the suit and said, actually, we're not going to defend this 2024 map. We don't have any interest in this. So it ended up just being non-black voters versus black voters, but Louisiana's name stays on the lawsuit for clarification. A 3-judge district enjoined the use of this map in 2024. They said, nope, can't use this one, which kicked it back to the 2022 map, which was also enjoined. So I really don't know what they thought was going to happen. The Supreme Court then issued a stay, which put the 2024 map back in place. So at the status quo at this point in time was that the 2024 map with the two majority-minority districts was in place. Then we finally, after some shenanigans with a rehearing, which I'm just not going to get into because it's too in the weeds, we finally get this opinion dropped last week talking about, it's really hard to say actually what this case is about. We have some disagreement within our own ranks as to the best way to phrase this. But the question really that's being answered is, does the Voting Rights Act, does Section 2 of the Voting Rights Act mandate racial gerrymandering? A subsection of that question is, does it excuse racial gerrymandering? And I think the answer to both of those questions is sometimes. Justice Alito says sometimes. And he's joined by the conservatives, and the liberals have a different opinion. I think it would be fair to say that the liberals' response to this is always, yes, the VRA always requires racial gerrymandering. And according to Justice Alito, in some circumstances, it requires racial gerrymandering. Is that a fair way to phrase that, Chance? What do you think?
It's close. I mean, I think one way to think about it is we all understand just intuitively, if you look at the text of, say, the 14th Amendment's Equal Protection Clause, whenever the government does anything solely on the basis of race, it's going to be constitutionally suspect. Yeah. Whether that be, regulation or whether that be drafting voting districts. If you are drafting something solely on the basis of race, that's going to be constitutionally suspect under the text of the Constitution. Now, the problem that Louisiana had in this case is they were arguing that under certain interpretations of Section 2 of the Voting Rights Act, and we could talk about the text of that act in a minute, which doesn't mention gerrymandering at all, but there was an interpretation of the Voting Rights Act that it actually required them to draw majority black districts. So they had to take race into account under a certain interpretation of the Voting Rights Act. And they argued that, therefore, to comply with the Voting Rights Act was a compelling governmental interest that allowed them to violate the text of the 14th Amendment, which demands equal protection. And so the question before the court was really, one, is the Voting Rights Act a compelling governmental interest? And two, more importantly, does it actually require you to do race-based districting? Does Section 2 of the Voting Rights Act require you to base districts solely on race? And where the court shakes out is most of the time, no.
Most of the time, no.
Almost certainly no. right?
Yeah.
And so
let me lay out real quickly, as quickly as I can, because it's kind of a long section. Section 2 of the Voting Rights Act. I think it's important to understand the language that we're working with here. Subsection A reads, no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of his race or color, or in contravention of the guarantees set forth in section 10303 F2 of this title as provided in subsection B, which brings us to subsection B. A violation of subsection A is established if, based on the totality of the circumstances, it is shown that the political process leading to the nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. Okay, to me, this reads like word salad a little bit. And I think to a certain extent the court has agreed with that over time, because the race to find some sort of meaning in this language has been fraught at best. Clayton, you laid out earlier some in previous conversation, some kind of theories about what's really going on here and about constitutional avoidance. Can you explain what your thoughts are on all of this?
Yeah, basically. So, my understanding of the majority opinion is that they, they're trying to read the text and apply the text of the Voting Rights Act in a way that comports with the Constitution, with the enabling clauses of the Constitution. In the 14th and 15th
clauses for people who haven't read their Constitution recently.
What are enabling clauses?
Yeah.
So when the Civil Rights or Civil War amendments were passed after the Civil War, there were protections in those amendments for individuals within the states from state power, and the Constitution, those amendments gave Congress the power to enforce those individual rights as against the states that were abusing them. So that is applies to equal protection, due process, individual rights, voting rights. But yeah, so basically the task of the court here was to read. They're basically bound by the Constitution to read the Voting Rights Act as being able to fit within one of those enabling clauses. And if they read the Voting Rights Act to exceed the enabling clause, then that would be an unconstitutional interpretation of the act, and therefore the act wouldn't stand. So it's just pure and simple doctrine of statutory construction, canon of statutory construction, to read the statute in a way that does not offend the Constitution. And so the Constitution, as articulated by the Supreme Court, only allows certain race-based intentions to be sought by the state. And the Supreme Court here says basically, we've never held that this particular motivation is part of what the Constitution enables.
So by this particular motivation, you mean specifically compliance with Section 2 itself is not on its face a compelling governmental interest. You have to have something else.
Yeah, it can't be the case that Congress just gets to define for itself what is a compelling interest. That was decided in a case called City of Bernie versus Flores. It's a 10th Amendment issue. It has to be as the court defines it. How does the court articulate the outlines of the rights that the enabling clauses permit Congress to pass statutes to enforce, and therefore what the court should interpret this statute to be? Does that make sense?
Yeah.
Yeah. And so if you think about the way that the majority kind of walks through thinking about this statute, is first it starts with the 15th Amendment is, prohibits discrimination in race and voting. The VRA is adopted under the enabling part of the 15th Amendment. And then you look at the text that you went through earlier, and the first thing that it does, it says, like, if you deny access or ability, or, I forget the exact term there, but it's basically things to an individual's right to vote. Like if you're basically some sort of practice that's adopted to stop people from enjoying the right to vote, that would seem, on the basis of race, that would seem like some sort of affirmative bar to participation in the franchise. So
yeah, the language that they use is that its members had less opportunity than did other residents in the district to participate in the political process.
Right. So that would seem to be some sort of bar to voting. And they say clearly when you're talking about redistricting, that's not what you're talking about. And then the second part of that, though, is there seems to be this clause that's added in the 1980s that says specifically that you can look at the outcome of elections in some sense, or like the districting process, to determine whether maybe there's some sort of, whether the prior clause is actually happening, right? So
yeah, I think it might help if we give a little bit of background on that specific thing that happened in the 80s during the Reagan administration, actually, which is fascinating. So actually, I think, Nathan, you had some good insight on this.
Yeah, so there was a decision, 1973, I believe, White, which determined that sort of this more strong, sort of toothy version of the VRA that, and it used that language, that the members had less, if members of a protected class had less opportunity than did other residents in the district to participate in the political processes. And so it's really looking at like an outcome of, and it was a gerrymandering case. So they were the districts.
This was White, right?
This is, yes, White.
Okay.
And so I was looking at this 1973 case of gerrymandering and saying if they had less opportunity, and so kind of looking at the outcome again, then that would be enough to trigger like a violation of the Voting Rights Act.
So White held that a discriminatory effect is sufficient to trigger a violation of the VRA.
Yeah, that's pretty close. And so that case was law for about 7 years, and then a case came out in 1980 called Bolden, and that made it more about discriminatory intent more than discriminatory effect. That case was not well received in the media and by the public a lot, and so the Congress at that time in 1982 amended the Voting Rights Act and actually included a lot of the language almost verbatim from White, trying to get back to this stronger version of the Voting Rights Act, or at least the people who, the members of Congress who wanted this language included, wanted to get back to like a stronger version of the Voting Rights Act that actually could allow for racial gerrymanders when necessary to offset when its members had less opportunity than other residents in the district to participate in the political process. And that was not just, as Chance was mentioning, that wasn't just things like poll taxes and things like that, but it was vote dilution is the idea that by spreading out minority members into different districts, that you're diluting their potential to elect who they want.
Can we unpack that just a little bit to talk about cracking and packing in like 30 seconds to give an idea of what they're talking about there? So you can imagine a situation where you wanted to exclude a particular race from prevailing in an election, where you had an urban center, for example, with a lot of black residents, and around it, there's suburbs, for example, where there are a lot of white residents that vote a different way. And so what you would do, as opposed to creating, a district for the suburbs and a district for the urban core, and both would get a representative, you would draw it like a pie slice, where you had a little tiny bit that goes into the urban core, and then the fat piece is out in the suburbs. And that way the urban core is broke up and can never actually elect someone that represents those interests. So you can imagine a type of gerrymander where you draw the districts deliberately to stop, like, for example, depending on the demographic patterns, a black community or a white community or a Hispanic community from being able to elect the person that they would prefer to represent them. And you could imagine some way that you did that intentionally to effectively disfranchise certain people. And in that situation, you would have never actually done anything that stopped them from voting. This is the theory. But you've made their vote effectively, you've neutralized it in ways.
Right. You've outnumbered them 100-1.
Right.
What are they actually going to be able to do?
This is the argument of what they're trying to get at, but the text of the Voting Rights Act adds something, which is interesting afterwards.
Yeah, let me pull that up.
So the text of the Voting Rights Act at the very end says, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population.
Yep.
In other words, you don't have a right to not be part of the pie.
Yeah.
So by saying that, everything that's before it, if you read all of the language that's before it to mean, nope, we can't have a discriminatory effect, which is sort of what the court has assumed for a long time. Discriminatory effect is the problem. That last sentence says, except that you don't have a right to not have a discriminatory effect. So what weight is subsection B actually carrying?
Well, and I think people need to realize, because there's been a lot of controversy about this decision, they have to realize why it's complicated. Because again, you have this background principle that says you can't draw districts on the basis of race under the Equal Protection Clause, unless you're trying to fix a previous race-based gerrymander, right? Like if you're trying to remedy a previous example.
Right. 10 years ago, the legislature did a race-based gerrymander. We got to fix it now.
We got to undo that race-based gerrymander. But so under the 14th Amendment, you can't make decisions on the basis of race. Then you have this statute that says, yeah, but if we look at it and the outcome is really, really bad, then we can perhaps do something about it. Mm. And then the bottom of that same statute says, but you also can't do proportional representation on the basis of race. And so the question becomes like, how do you interpret this word salad of a statute to where it doesn't violate the Constitution?
So do you want to know what Justice Alito says?
Yes.
Justice Alito lays out what he calls a new test, or rather what he calls a gloss on the old test, which was called the Jingles test. And I don't think we need to get into that because it's very, very complicated.
Yeah, let's not do that one.
For right now, there's three different prongs to this test.
Yeah.
And the plaintiff, so the person alleging that there is a VRA violation, has the burden in all of these. So to prevail, the plaintiff must, quote unquote, disentangle race from politics by proving that the former drove a district's lines by presenting a new map, which Justice Alito says this is commonplace. At this point, everybody knows you got to get a computer to draw a map for you that shows that whatever partisan or race-neutral reasons that have been given for your map could be met in a way that doesn't do packing and cracking like you were just talking about. And therefore, the former, that is the race, drove the district's lines. So this very first prong requires that you demonstrate that discriminatory intent, which appears to be exactly what Congress was attempting, at least, to prevent by enacting subsection B.
What makes it harder is that political gerrymanders are perfectly fine.
Right.
So
not just perfectly fine. They seem to be extremely protected in the rest of this test. Let me get through this real quick, and then we'll turn back to that. They must show, this is prong 2, they must show that voters engage in a racial bloc voting that cannot be explained by partisan affiliation. So you have to show that all of the black people in this area are voting for a black person because they are black, not because they are all Democrats and they are voting for a Democrat, which is an extremely difficult thing to demonstrate. Where you have kind of this dual party system that Justice Alito talks about. And finally, they must show present day intentional racial discrimination regarding voting. So we have to show it's not that, we're remedying this racial discrimination from 10 years ago, or I suppose 10 years ago, we're still within the time frame to remedy current discrimination, but it's not 50 years ago. It's not 100 years ago. It's racial discrimination today is what they are remedying here. So it's a 3-pronged test. Plaintiff bears the burden on all of these things, and in all of these is wrapped up what Nathan just pointed out, which is that partisan gerrymandering is totally fine.
Yeah, I mean, one of the things to remember is that the word gerrymandering, which should be gerrymandering, comes from a guy who was, like, at the time of the founding, drawing districts in such a way to benefit one party over the other. I mean, this is a very old process in the United States. For political purposes, the party in power is going to try and draw districts that benefit them in re-election efforts. And so what's actually happened now over the years under the Voting Rights Act is that it's being used for partisan purposes.
Right.
And not always in ways that you might imagine, because sometimes it may benefit, a party to pack black votes into one district because then they only get one. And sometimes it may make sense to crack them into many districts. That way that they don't get many for partisan reasons, because the reality of on the ground voting is that what we have in a lot of communities, it's that certain minority groups vote for one party as opposed to the other. And depending on how that breaks out in your state, you're going to see a high correlation between partisan gerrymandering in that state and what would look like racial gerrymandering in that state. And what the court's trying to do is find a way to disentangle those two things, because partisan gerrymandering is as old as the Republic, and racial gerrymandering would be unconstitutional.
Right. And that, I think, is the crux of this case, which is that racial gerrymandering is unconstitutional.
Yeah.
And that is what the VRA itself says. It's not that we have to do racial gerrymandering to comply with the VRA.
Yes.
It's that racial gerrymandering is itself unconstitutional, and the VRA is what helps, at least in theory, helps us disentangle partisan gerrymandering from this unconstitutional racial gerrymander.
Yeah. And that's a new thing, because the lower court in this case had, or not in this case, in the previous case, had required that Louisiana create another majority minority district. So they said you must do racial gerrymandering.
And it leaves us in a really weird place here at the end of the day, because if you're keeping track at home, we end up 6-3 overturning this map in Louisiana. And I think the answer is Louisiana doesn't have a map right now. I think they have to go back to the drawing board, right?
That does seem to be the outcome. They've said that they're going to do that.
Yeah.
I don't know if they're going back to the 2022 map, or if there's, because as far as I can tell, that one is still enjoined.
Yeah, and if you think about it, it really opens up, I think, the floodgates for a lot of different gerrymandering going forward, because there used to be this thing that like, oh, well, everyone wanted to do the political gerrymander, but then they knew that they might get a challenge from either side.
Right.
I mean, think about this case. This was originally the black voters challenged it, and then later when they redrew it, the white voters challenged it. And so depending on political affiliation, there was, as long as you're having to do racial gerrymanders under the VRA, there was always going to be a VRA challenge to whatever map you drew. And now I think state legislatures are going to have a lot more freedom to engage in the traditional political gerrymandering that they always wanted to do anyway. And so it'll be interesting to see how this shakes out.
Yeah. So we've got 3 minutes. Clayton, do you have thoughts on Justice Thomas and Justice Gorsuch's concurrence in this case?
Or anything, since you've been quiet most of the time with your technical difficulties. How was your day?
Well, good. It's a fresh day. Well, no, I mean, I think anyone can jump in here, but I think Thomas's concurrence was interesting in that he emphasized that it was what the voting rights really sought to do is to protect individuals. It applies on the individual level and not in the macro aggregate collective level. So as long as an individual person, no matter their race, can have access to whatever ballot is placed before them, because at the end of the day, we all are relegated to the choices that the parties and the system places before us as voters. We're all sort of limited in a fundamental way like that. I think the opinion sort of opens with that. But as long as an individual can participate in the same way, make a free choice of the things available to him as his neighbors, then you've complied with the Voting Rights Act. There's not all of these other sort of broader societal questions are not quite in the text. Do you guys think is that a fair assessment?
I think that's right. I think that it does two things that I think are very familiar from Justice Thomas's jurisprudence. One, it takes us back to the text, and it says like districting is not in the text of the VRA. It protects an individual right, not some sort of group outcome right. And two, it goes back to something that I think has always really deeply offended Justice Thomas, which is the presumption that someone will behave a certain way or act a certain way because of their race.
Right.
And built into the whole idea of VRA racial gerrymander is this idea that all black people are going to want to vote the same, or all Hispanics will want to vote the same, or all white people want to vote the same. And Justice Thomas has always found that deeply offensive and inconsistent with ideas in our Declaration of Independence. And so to see that from Thomas and Gorsuch, who joined, really tracks that sort of, it's not in the text and it's inconsistent with these principles of, individuals are what matter, not groups, which is something that's a big part of his jurisprudence.
I want to get to something briefly, if I can. the coverage of this, like in the media and stuff like that, has been very harmful, I think, to both how we analyze the court and how we analyze this decision in particular. But it's not just this case, but this case provides a great example. So, like, here's some headlines from NPR: Supreme Court paves the way for the largest ever drop in black representation in Congress. New York Times: How the Supreme Court demolished the Voting Rights Act. The Guardian: Politico: The Voting Rights Act is now a dead letter after the latest Supreme Court decision. These are like very common things, and what they represent, and what often happens in coverage of cases like this, it's a complicated case. There's a lot of statutory text to unpack, and the court does a great job of doing that, but it takes like dozens of pages and some disagreement among the court to do that. But when you go to a short news story, you find that the information sources now are more interested in giving us emotional justifications for why their team should win, more than giving logical arguments about why the position that they agree with is right. And I think it's easier now than any time in history to have a position with having no rational basis for it whatsoever. And so I hope if this podcast does anything, that it helps to give you the tools to arrive at a conclusion based on what the decision actually analyzed, the same factors and what the court said, rather than just getting an emotional, yeah, rah, you're right, or no, you're an awful person because you're wrong.
Yeah, I think that if you get anything out of this, it should be, if you're going to have it, it's okay to disagree with the outcome of this case. It's okay to be upset about it. But if you're going to critique the opinion, then you have to do the work of going and looking at the text of the Voting Rights Act and saying, where are they wrong about their interpretation of the text? Not, I don't like where they ended up, but okay, well, if you want them to end up in a different place, like where can you base that in the text of the 14th and 15th Amendment? How can you make that square with the text of the Voting Rights Act, not just the outcome that you want?
Amen.
Amen. I think that brings us to the end of today's docket. If this podcast has left you with some tools, as Mr. Seltzer said, to analyze and understand this case and these precedents, please leave us a review. Tell us if you think that we're right in our analysis, and join us next time for more Rightly Decided.